the opening of the Oldham County Code Enforcement Board on August 4th, 2009. Is the approval of the minutes of July the 7th.
I move that the minutes be accepted.
Okay, we have a motion on the floor. Do I have a second? We have a second. All in favor say aye. Okay. Minutes are approved. Moving on to the citation. The first citation for the day is number 580. Okay.
Chris Clark, Code Enforcement Officer for Oldham County. I'm here to present information on Citation 580. Citation 580 was issued to Mr. Brian Davey. Citation 580 was issued to Brian Davey. Lives on Belknap Beach Road, Prospect, Kentucky. It's a zoning violation. Ordinance 250-140A4. I'll go through the slide presentation here. Mr. Davies, Belknap Beach Road, Prospect, Kentucky. Again, it's a zoning violation, 250-140. That's a little difficult to read. That's in your all's packet on exactly what the ordinance states out. This is a aerial map of the property owned by Mr. Davey. He has a riverfront lot. He has a lot behind that lot, and then he owns several acres adjacent to that as well. Specifically, there's the location of his residence, and the lot 2907 is where the majority of this commercially used equipment is stored and located. This is a photograph taken on the date the citation was issued. This equipment is used for tree removal, landscape, heavy timber type operation. As you can see in that photograph by the tree there, that's a, if you want to call it like a wood chipper, shredder type thing where you can put tree branches, etc., and it take that down to sawdust. There's another one of the equipment trucks he had on property on the date the citation was issued. Citation 580. Real issue here is that this is a zoning violation because that's all zoned residential. That's heavy equipment that's parked in a residential area. So thus the citation was issued, obviously. This is an update as of about 3 hours ago. The truck you can see is still on property. And I tried to get another angle of it there, still on the property there at his residence. And Mr. Davies not here today. He had been in communication with me that he would attend, but unfortunately he's not here. That's basically all I have to present on that. Unfortunately, this property and the owners have had a history with this exact ordinance. He has been before the code board before, and what we've run into is, unfortunately, he's not getting the importance of the ordinance. Specifically, he was before code or was issued citations in February of 16 as well as November of 17. So this is third citation for the same thing. If he was here, he would tell you that he uses that equipment for his property as well as for helping out neighbors. He has told me in the past that he's planning to build some type of garage to store them down there. Nonetheless, it's heavy equipment, it's commercial equipment, and it's zoned residential. So I really don't have any gray area on this.
board member, does any of the board members have questions?
Ordinance. Of the neighbor. What specifically the issue here is that this is commercial equipment that is used. I mean, it's heavy equipment that really needs to be out of a neighborhood, out of a residential area. If this was a short-term issue, you know, for a project or obviously post storm, something of that nature, I would understand. This is an ongoing, this is just an ongoing problem with this location, and he's storing the equipment on his property. He has a form of employment where this is what he does, you know, tree removal, maintenance. There's some other types of equipment methods he uses to make an income, and storing the equipment on his property is unfortunately what he's doing right now. It has in the past, obviously.
Other questions?
Have there been complaints from the neighbors? There been complaints from the neighbors?
Yes. Really what's going on down there is that there are neighbors that are moving in, neighbors making improvements to residents. Some homes are being newly constructed. And so people driving up and down that road, seeing equipment such as this, it's not what they want to look at, obviously.
And this is his third offense?
Be his third citation. He had a citation in February of 16, November of 17, and then this citation issued in October of 20. And so, yes, this is.
Okay. Discussion?
Kind of go back to my question. Is there an ordinance that says it's okay, or simply because you said that one of the things he said was that his equipment helps out neighbors? Is there an ordinance that makes that okay?
I'll answer that for you. There isn't, you know, it typically is related to the type of land use and the zoning classification. It doesn't distinguish between volunteer work or if there are clear markings of a business on vehicles, if they're of a certain size. That's where it gets into the zoning classification, and this zoning classification doesn't support having this equipment on this property, regardless of whether it's for business use or for volunteer work. It falls into that business category.
Clear distinction there is he never said volunteer. He said he was helping out neighbors. He didn't say he was not charging neighbors. He could be charging them too, but
This is one where he'll take equipment away and then bring it back, and then the neighbors tolerate it and then call us. And they've tolerated it for a while, and now it's back. And you've seen from the pictures that Chris showed you that it's not just one piece of equipment, it's several pieces of equipment.
This is his second violation,
Third.
third violation.
Or this
I
will be,
think we need to move to the next level. I think it needs to be a legal level, because he's not even here. It's not even important for him to even be here to deal with. He needs to know that it's a serious situation that we're dealing with. This is the fourth time that we're dealing with this. Why?
This actually, you're right on track with why we're here with this case. When we have folks that either keep getting citations and paying them, or getting citations and not complying. We've talked to Matt Hudson, and Mr. Carter is here filling in for him, but Matt has informed us that these could be criminal charges after, and so we're really bringing it to the code board to give it that point of severity where either we take action of some sort or then we file a criminal complaint. And you will start seeing more of these cases in front of you because we have some that are kind of unresolved violations of the code.
This may be a technicality, but since he's not even here, is that considered an uncontested? I could argue that both ways.
He didn't contest the citation, but we gave it to him with an appearance date. So really, it is let's call it uncontested, just so we can. But as a repeat offender, he's also not mitigating the issue. So let's view it as uncontested because we just told him he had to appear. Just like last month, there were a couple of cases where we told him the same thing. You haven't solved the problem. We keep giving you citations. Here, let's get in front of the code board, take official action that then can either get better resolution or go on to the court system.
So the fines would go back to the original citation day per day.
That would be a decision that I guess you all would have to make as far as if you wanted the fines to go back to that date or if you wanted to adjust in any way.
Our records, I guess, give suggestions as to what the first, second, and third offenses are per day. But when does that start?
Yeah, usually it starts with the date of the citation, and then we can go a number of different ways. If you add that up per day, then it can get to be very high-priced fine. But then, as in general, the code board has the ability to require a certain amount be paid and a certain amount be held in abeyance if, in fact, the property is then mitigated and it clears up the issue. Then that money, that fine that's in abeyance goes away. That's the point that we typically come back at a future code enforcement board meeting and say, here's the resolution of that. Or if it's not mitigated and they don't pay that amount, we bring it back and say, all right, now we need to go and take the next step, which could include even liens on the property if they haven't paid it. So again, it typically you can do it per day. And then what we try to do is give a logical, all right, what's the amount that you're going to request be paid immediately and the rest held in advance? You can take the whole amount if that's what you want to do. Say that's what your fine is. But this one, again, hasn't been contested, and they also has not paid the fine attached with the citation.
The 2016 and 2017 violations, were anything paid then? Or were they mitigated? Did he move the vehicles?
What had happened was he came to the code board and things had improved to the point that it was, I don't want to use the lock term dismissed, but code board let it go. But again, what Jim said, we're seeing a pattern here where it goes up, it goes down. And so that's why we're here today, is that this is a continuing issue and someone who's kind of developed a way.
Cat and mouse.
Any other discussion? If we're ready to move forward, can we use the procedural matters on page 3 of 7 to start the process?
What are the fines?
$150 for this citation.
Who would like to start? Would you like to start? Procedural matters?
Appears to me that the citation was properly issued. told about the hearing. Seems to me as if all the procedural matters have been done properly. I'd make a motion that we accept the procedural matter.
Okay, and do I have a second?
I'll second.
Okay. All in favor, say aye.
Aye.
Okay, that motion carries. Okay, let's move on to the zoning ordinance violation. Who'd like to take that?
Well, it appears as if it is in conflict with the zoning ordinance, having reviewed and being presented the ordinance, that there is a commercial business being run out of a residentially zoned area. So I would make a motion and agree that there is an ordinance violation here.
Okay, we have a commercial activities going on, so it is a violation of the residential. I have this motion on the floor. Do I have a second? Okay, we have a second. All in favor, say aye.
Aye.
Okay, do we have a determination of penalty, remedial order?
I guess I'm confused. First offense that we have here on page 6 of 7, all the way to the third offense are different amounts per day. But going back to October of 2020, you're talking almost 10 months ago. The quick math I did, based on $400 a day, is $108,000.
You've done it that way and it resulted in that kind of number. In this case, and usually we aren't lapsing this long in between, with COVID and everything else, there was a whole different set of circumstances in terms of meeting and everything. So what would be best probably is to determine a one-time amount and then take some kind of action in your next step that says get it cleaned up or come back. And what we'll do is we'll then go out, and if it doesn't mitigate, then now you've got another citation. And we can then get into a per diem that will be more reasonable in terms of the amount. My gut feeling is that that mitigation period shouldn't be long at all, because this is an ongoing issue. It shouldn't take them 30 days to do it, but that's again in the next phase. So I would say just determine that amount based on what we know of this citation and that amount.
This is the third time, right, or fourth time. Maximum fine that can be paid. We've been dealing with this too long, and so it is of my humble opinion that he's been dealt with. He's been asked. He hadn't even showed up. But in my humble opinion, it's not a big issue because of the problem, the way it's been handled before in the first, but probably in the past. So we need to put a stop to this, or we need to make a stand, or we need to show, or we need to do something. So my thing is, what's the maximum fine that we can oppose? Because this is not the first time.
I understand where you're coming from. The situation is that he has had the previous offenses not within a 12-month time period. And so if you have them on separate calendar years, for lack of terms, it's going back to a starting point of offense 1. So he's had multiple offenses, that's correct. He's had them on separate years. The fine fine one, which is $150.
To ask.
Oh, is your next step is the one that's really going to get action, and that is that now we stay on top of it in terms of keeping up with your mitigation requirement, and then additional citations if that's what it takes. And so we've got to really start from today.
Or we to determine an amount? Is that what we're waiting on?
But that's the step that you're on now, yes.
Mr. Turner, I completely agree with your previous comments. Not showing up here today is an indication of the seriousness in which this person has taken the citation, and I think that something needs to be done to get their attention. I've got a number in mind, and I'll make a motion if it's okay with you, and I'm open to suggestions by either member. But I would say that I'd make a motion that today that the fine be $1,000 and that $2,500 be held in abeyance until the give him 30 days to get it cleaned up, and within.
Fine.
Okay. All right. I'd say $1,000.
As to council, can they actually fine additional above and beyond what the fine amount is on the citation?
Down on the citation.
He's recommending, yes.
No, it says per day, isn't it?
Well, then you have to go back to the total amount, of that, whatever, 100.
Oh, and I had gone back. Chris clarified for me, though, that I had included all the previous years too.
It's going to be a proof problem. That is, you can't prove that he had the equipment on the property except the day the enforcement officer was there. You're assuming something you can't prove.
I'm assuming we're going to October 14th, 2020. When he was cited and he still hasn't fixed it. I'm assuming per day be about 300 days. So at $150, even if we went down to uncontested first offense, $75 per day, that's $22,000. And I'm with you, Mr. Turner. I think we need to put an amount in front of him that makes him know we're serious about that. And I don't think 1,000 is enough.
Establish a what?
On that? Okay.
I think you can't just assume there's a violation. Like, hey, you don't prove you had the truck on there. Nobody was there to see it.
He was there 3 hours ago.
Huh?
He was there 3 hours ago. We have pictures of that.
3 hours ago, that's another violation.
One of the ways we could potentially do it is to say that every time that our code enforcement officer went there and saw the violation, that's a fine, because that would be, and then base it on
3 times.
I'm just in there with the equipment on the property.
So now we have evidence. The code enforcement officer goes 3 times, establish a fine based on 3 times. That would work.
So with that being his third offense, it'll be only the first on this citation. So we have to go back to uncontested. That's $75 a day, 3 times 3. It's not very much. You'll pay that and move on.
So, but
It's in the citation, it says 150. So the citation amount was 150,
$450.
that number times 3, because that's what we told him. If he were to just pay the fine, then that was it. It's when you come in and talk to the code board that you can get some kind of relief from that amount. So he was notified in the citation, it was 150. Code enforcement officer observed 3 separate days where the equipment was there. So 3 times 150 is, if that's what you want the fine to be. And now at least we're on standing where I think Mr. Carter would agree we're okay.
I guess my previous motion being out of order, now we'll rescind it. Sounds like the penalty be $450. I'd make a motion that the penalty be $450.
Motion on the floor for fine of $450. Do I have a second? Okay, we have a second. All in favor, say aye.
Aye.
Snake, okay. We need to talk about the terms of a remedial order.
There have been 3 citations on this property in the past over several years. He's had since October 2020 mitigate this scenario. My recommendation would be that he remove the commercial vehicles and every evidence of running a business out of that property within 14 days. And after that, Chris can go out and do an inspection, make sure that on day 15 it's gone, and if not, we'll issue another citation. Now we're establishing that rhythm, if you will, of how many times are we going to observe, and then the penalties get, now it's the second violation in 12 months, and then we're also at a higher rate and more observations. So this is remedy.
I guess my concern is, are we being realistic and asking him, even now, after going through all this, are we being realistic and asking him 14 days? Why not give him 30 days? That would make, that would me solidify this. That would make this whole. We're not only giving him time, we gave him 30 days to do this, not 14 days.
It's absolutely up to you, but this
And the question,
equipment is on wheels and operable, and the neighbors have had to put up with this for a long, long time.
so, I mean, Mr. Inspector, do you believe that he can get this stuff out of there within 14 days? Just based on what you've seen?
The ability. He travels out of town quite frequently. That's another factor that has led to this delay, along with technology issues at his residence. But he has the ability to move those items.
You want
Any other discussion? Are you making a
Make a motion that he.
a second?
That'll be as of tomorrow, because then this way, Chris obviously may not get a hold of him today, so the 14 days, just for the benefit of having one extra day, starts tomorrow.
All right? As the board has found, is a fine of $450 with a remedial order for all equipment to be removed within 14 days as of tomorrow. Is that correct? Okay, all in favor say aye.
Aye.
Okay, okay, the motion is carried. On to the next case.
Okay, next item on the agenda is citation 602, which is issued to Mr. Daniel Cooper, 7501 Lone Oak Court, Crestwood, This is a construction site runoff violation, ordinance 05830-3267. For the purpose of testimony on this, I will be bringing a witness forward simply to describe the site. The owner of record of that property is Mr. Daniel Cooper, 7501 Lone Oak Court. This photograph, I believe, was taken a day before the citation was issued. And at this time, I'd like to bring up Eric to present some evidence. And then I'll be happy to answer any questions along with Derek.
Okay. My name is Derek Shea. I'm a Oldham County staff engineer. I work in the engineering department. I'm one of the primary individuals that does construction site inspections for large developments such as subdivisions on residential, commercial, industrial sites in the county, and I also do construction site inspections for individual lots in residential subdivisions. The subject property that we're discussing today, as I was doing other individual lot inspections within Brentwood, I came across the subject lot, and it had bare soils on it throughout the extent of the lot, and I did not notice any perimeter control measures on the site. Usually when we find a lot such as this, are there other photos you want me to go through? Or here's another photo of the project site. Those are the only two that pertinent. All my other visits, they were about the same. Bare soils, no perimeter controls, and no final stabilization. So the first letter that you want me to go through the letter timeline as well? Okay, so the first letter that we sent, usually when we find a lot like this, that appears to be a finished grade, which is what we call what we're seeing right here. Usually this is the grade that it's at right before they either put sod in place or they do seed straw or something like that. Usually when we find a lot like this, we'll reach out to the owner or builder. We basically say, okay, we've seen your lot. Here's your finished grade. According to our ordinance, you have 14 days to get it under final stabilization. Usually final stabilization either is sod or it has to be under seed straw or some type of mulch or something like that, so there's no bare soils present. Second time I visited was past the 14-day period. I don't have the exact dates. But the second time I went, it was past the 14-day period. They had no silt fence. It had no other appropriate type of perimeter control, which would have been like maybe straw wattles or something like that, which we would find acceptable. And there was no permanent stabilization on the site. So there was no sod, there was no mulch, there was no seed straw. At that point in time, we issued additional correspondence to have the individual get the site under stabilization.
Also note, I went out there today to the site. And this is what it looks like now. So you can see that back when the citation was issued, obviously it was a bare, empty lot with bare soil. But today, obviously the grass is growing and looks healthy. Mr. Cooper is here. That's all I have.
Thank you. Mr. Cooper, would you like to say something? Okay, we'll have you come up and raise your right hand. Okay.
You solemnly swear or affirm that the testimony you're about to give this board is true and accurate to the best of your ability.
My name is Daniel Cooper, resident at 7503 Lone Oak Court, right next door to the lot. Many things that were said were true, some are not. Notice of compliance was given to a Clifford Thiemann at the time of May 3rd, which was forwarded to me in an email, but never given to me officially. Exemption of 153.05 says the following activities are exempt from provision of this chapter. Any redevelopment or renovation does not disturb more than 2,500 square feet of the land, which all I did was add dirt to this lot. I never disturbed any dirt that was on the soil originally when purchased. The perimeter control plan is for the permittee shall secure the perimeter. I never got a permit, never knew I needed a permit to add dirt to a lot to level it out. So I never knew any of the parameters that would be as the permittee of all these violations. This one we discussed here, the citation, section 7. Focus on the downstream points, the outfall areas. That's in the back left corner. There is no downfall or output areas in the front area, not necessary protection of the entire site boundary. There's a silt fence along that back line. It's covered by growth, which protects any erosion towards the back end. This front end here is many inches above. I can show you all the yeah. So this is quite a lot what the site looked like when I first moved into the neighborhood. There's no silk fencing, any of the perimeter. Water just flowed all over the place onto my property. Eventually I called and someone put a silk fence up. In the one section you see on the northeast corner there is no silk fence. It's due to egress and ingress of the property. That's the main section where that first 6 to 10 feet would flow onto the street. What I had on my property would flow across, that was the silk fence in place. All the erosion on the property, the silk fence did nothing because of the actual grade of the property from the builder or developer, and that would flow straight onto my residence. And one of the primary reasons I purchased the property was to rectify it. Oh, the water there, that's my house. Then I had to create to alleviate the water along the back channel, which here's the plan that was reported to me from the development, which way all the water should flow. The arrows and the double dash there are the ones that indicate which way it should flow. I regraded the whole property so it actually flows this way to the back, over through a channel, goes this off the down here on the main drain, down to the street. Cool. Then some more pictures. Here's the grading. These are all the numbers of the difference. One central point. Highest point is 80 inches, that is 0. All these numbers infer that all the water from the curb line all the way flows back. No point with my dirt going on. That was all the dirt I bought. Still in the lot. Of dog dirt. This dirt viewed in these pictures here that coincide with Derek's pictures are ones of dirt flowing from the top of the apex of the street there down towards my house. Okay, that my dirt is migrating, but at no time running down along this curb line. All the truck tires really run through the neighborhood. There shows all the stream of water that I've graded to towards the back where it runs through. Highlight areas and where it's running. Now when it was time to seed it, it snowed prior to that, so the soil temperature was below 70 degrees. The seating and straw was not a viable option at that point. Then on the 13th, for a specific timeline, purchased the property on the 17th. I spent 5 months trying to find a grading company or a excavating company to grade the property. There's nobody in that area because of all the development going on that wants to come to a personal residence and operate for me. No one would return any of my phone calls. The one person I had come back for an estimate just never came to do the job after he agreed to do the job. On March 21st, the dirt was delivered. March 29th, I rented the Bobcat and a grader. I couldn't even rent stuff around here, so I had my dad drive from New York with a tractor and trailer to then pick up the Bobcat to excavate all this and work the property. Throughout March and the end of March and most of April, I was letting it settle and regrading multiple times over and over again, as multiple neighbors can attest to make the dirt all flow the proper way. And on May 3rd, a notice of compliance was issued to me, again, stating that the section 7 and 10.8, which doesn't exist, it's 10.8, which is really hotel, required for the individual lot, which is really separate stormwater permit is not required for individual lots disturbing less than 1 acre. This lot is only 0.33 acres, so that doesn't apply. And then I've got records of from my hydroseeder that I hired. That's really backed out of me, and that was on May 10th. It's going to be another 2 weeks. I've ordered material, and nothing will come in. And then he says, "All right, Mr. Cole," and fired him pretty much because he was unreliable at that point. Sorry, I'm not on the microphone here. Let's see. Covered that. Let's see. This picture here was taken about a day or two after I received the 2 more truckloads or 20 yards of dirt to grade the soil right outside the forms for the sidewalk, which on May 13th, I was between correspondence between Derek and Vic in the county here. Come to light that I needed to put a sidewalk in. It was a requirement to put in. Prior to that, I was discussing with the developers and the project managers in Brentwood there, and they said I do not need to put a sidewalk in unless neighbors complain that it needs to have a sidewalk. So once I found out it was a necessity, I went ahead and moved on to the sidewalk, so I couldn't seed or sod until I put the sidewalk in, which I've got emails and texts between me and the company that there was a shortage in cement in Crestwood area, so not until June 3rd was I able to get the cement poured. And then shortly after, on June 6th, I made the movement to lay seed and landscaping blankets to stabilize that front section. And I hydroseeded the back using tackifier and biostimulants and seed to stabilize the soil and to grow seed back there. What else here? Question at this point? There's a picture of that dirt that was dropped off on. So I had the forms put in on the May 22nd, and because of the forms going in, it raised up the ground 3 inches when I put the sidewalk in. So I would have to regrade. So that's another 20 more yards of dirt dropped off. And that's the picture that Derek has there of the what looks like a lot of dirt spilling onto the road, but it was just days after the dirt was just applied to the property. So say that sidewalk going down. Is there a worker in the neighborhood I could find? It's my 3-year-old daughter. She was able to pick rocks up and helped me grade the lot. Day I was laying seed, there was a massive thunderstorm came through, and then I was able to get it stabilized. Even after, you can see the mud there is coming from the upper portion of the neighborhood and not my street and not my lot, because it had it all wrapped up in a blanket. And then these pictures. That picture there is about 5 days ago. When I came home from a trip, I took a picture of that. And that's after my grass is grown, my soil stabilized. There's still plenty of mud by that storm drain. And that's all from the upper streets that also have silt fences. So I personally deem they are ineffective, but they do their job of mediating water and cooling. There's the lot today. There's also more dirt in the next lower section down the street that all is from truck tires tracking dirt through the neighborhood and getting flushed into where my section is, since I have, on both of my properties, have 2 storm drains, which are low points in the neighborhood, which all the mud flows to no matter what I do to my lot. And all I've got for now.
All right, sir. Thank you. Don't mind having a seat? Just a moment.
Chair, I have some questions for him.
Just a moment.
Okay.
You know?
Yes, please. Do we have a chance for rebuttal from the county? Anybody have rebuttal? No rebuttal? You can go back up. Sorry. You can ask all the questions.
So I understand your house, if you're standing on the street, your house is to the left, correct?
Correct.
Who did you buy the lot from?
Clifford Thiemann.
And is that a builder?
Yes, he's a builder developer, or he's a builder. And in the email here, there was confusion on who actually owns the property. And that was, I don't know if the records were incorrect or what, but when the property was purchased, it went through the transfer to me, and that's who the email went to. There is Clifford Thiemann was the original email sent to him, and he responded, "We do not own this lot, but we'll forward the information to the homeowner since he had my contact information. And please find the attached notice of compliance." Like I said, I spoke to Derek on that day and gave him my plan, and then followed him in writing that I had efforts to fix the issue, and that the people who were, I guess, the hired workers that I was going to hire to stabilize the soil then backed out on me and wouldn't come service my property anymore. So made every effort possible. I'm only a homeowner. So then at that point, when he backed out, I started buying all the stuff myself, renting the tractors, and till the land myself to stabilize it. That was after the 14 days. So as I was on the tractor ride around, I received the notification that I was being violated. So
How long had you lived there prior to approaching Mr. Thiemann about purchasing the property?
I lived there since June of 2020, and I purchased the property in, I think, September. So he didn't own it prior to that. It was the developer had it for many months. And he had just bought it early, I'd say probably August of 2020. Any other
When
question?
did you buy the property?
Property in September 17th, 20. Time there was, I don't know if you can see there in the picture.
This notice go out to Thiemann that he was in non-compliance. What date did that
May
go?
3rd. May 3rd, that letter went out.
Thing.
Oh, yeah. Not my department.
I mean, there's a lapse of time when a piece of property is bought in Oldham County. The record holder is listed, always listed as the person that owned it on January 1st. So I don't know. It should have gone.
Pay the taxes on it. I have the deed. I don't know what else to tell you, sir.
Any other questions of Mr. Cooper? All right, sir, now we'll give you the opportunity to sit back down again.
Thank you.
Ready to come up, make a closing statement? You want to make a closing statement?
No.
All right, so we're going to open up for board discussion. Can we open up for board discussion, please?
Okay.
Seems to me like the previous owner of that property left it in a way in which it was unacceptable from the beginning.
In my opinion, he's in substantial compliance.
He is in substantial compliance. Cooper?
Cooper.
Agree.
Oh, so we have to go through some motion.
Correct.
Evidenced by the code enforcement officer, the grass is growing. In compliance.
You were issued your citation while you were on the tractor. Is that what you said? But that was May 28th. Yeah. Okay.
Hey, if the board is in agreement that he is in compliance, I need a motion.
Make a motion that he was in compliance the time that he received the.
Want to go do the whole thing? Okay. All right. Okay, let's go through the proper format. You have to start with procedural matters. Who wants to do that? You want to do it, Mr. Tuck? Okay. Procedural matters, we have to start with that on page number 3.
I'm not so sure that it was issued probably on April the 30th because it was sent to Mr. Thiemann rather than the current owner. So
That was appropriate or proper.
I'd make a motion that the citation was issued inappropriately and not with procedural matters.
Okay, I have a motion on the floor that the citation did not follow procedural matter. Do I have a second? Okay, do I have a, all in favor, say aye.
Aye.
Opposed, nay. Motion carries. Moving into construction site. Okay. The next step, nuisance. It's nuisance. Zoning.
Where
Go to number 2. Is it nuisance? Okay, over here. The nuisance.
And here again, if you find that actually there was a violation of the ordinance, then even though procedurally it wasn't notified, right, you can say that it was, and then you get on to the rest of whether or not there's either a fine associated with this or any other remediation.
from the way that I understand it, the nuisance wasn't not created by Mr. Cooper. So I would make a motion that there is not a nuisance ordinance violation here about Mr. Cooper.
Okay, we have a motion on the floor. Do I have a second?
Second.
A second. All in favor, say aye.
Aye.
Okay, motion carries. Okay, now we need to go to a remedial order or fine.
It appears to me that Mr. Cooper's done everything to already remediate the situation. Spent a lot of money doing so. I'd make a motion that no remedial order is necessary at this time.
Second.
We have a motion on the floor. Do I have a second? Second. All in favor, say aye. Is there a motion for a fine?
Do we need a motion to not fine?
Mhm.
To make a motion that we remove the fine due to he's taking care of the situation. Second.
Okay, all in favor, say aye.
Aye.
Opposed, nay. Motion carries. This one is done. Mr. Cooper, we thank you very much for your time. We appreciate everything you've done. Thank you, sir. By the way, your lot looks beautiful. Your lot looks beautiful.
Thank you.
You're welcome.
I'm working on making it better.
You will.
The grass is growing.
Mm-hmm.
Irrigation systems.
Oh.
About 6,000.
Great. Thank you. Thank you, sir.
Much.
Okay, we have some old business to tend to.
Old business, if you remember from the last meeting, we had Lewis Tabor lived on 524 going into Westport, and he is working on that lot, has been in communication with me, and we're seeing progress being made there. The second case you heard was Miss Julie Holder out on Highway 53. She has till the end of September, and we're maintaining eyes on that property as well. So,
Thank you for the update.
Did anything happen on that property?
I had something really positive to tell you all. It's to me that a lot of things are being shuffled around. Again, it's going to be very difficult for her. It's a challenge.
Thank you very much. Being no further business? No further business, we are adjourned.